Hello, I'm Maharashtra Bhaumik and welcome to The Hindu. A huge controversy has erupted over the popular YouTube show India's Got Latent after the Maharashtra Cyber Cell registered an FIR against podcaster Ranveer Allahbadia, comedian Samay Raina and others for allegedly broadcasting obscene content. This follows another FIR registered by the Assam police back on February 10th. But what do obscenity laws in India exactly entail? How have courts interpreted them over the years? And where does one draw the line between obscenity and the right to freedom of speech and expression? We break it down all for you in this video. Section 294 of the Bharatiya Nyaya Sanhita criminalizes the creation as well as the sale of obscene materials, including electronic content. It defines obscenity as material that is lascivious or appeals to the prurient interest, content that is overtly and excessively sexual, or that has the potential to deprave and corrupt those who consume it. First-time offenders face up to 2 years of imprisonment and a fine of up to 5,000 rupees. Additionally, Section 295 penalizes the sale of obscene materials to minors, whereas Section 296 criminalizes obscene acts in public places. The transmission or the publication of obscene materials online can also be punished under Section 67 of the Information Technology Act of 2000. The definition of obscene materials under the IT Act is similar to that provided under Section 294 of the BNS. However, it prescribes a more rigorous punishment, that is 3 years of imprisonment and a fine of 5 lakhs for a first-time offence. With no comprehensive definition in law, the interpretation of obscenity has evolved over time when it comes to Indian courts. Until 2014, courts in India used the Victorian-era Hicklin test to determine what constitutes obscenity. Established in the English case Regina versus Hicklin, the test held that material would be deemed obscene if it had a tendency to deprave and corrupt individuals susceptible to immoral influences. The standard assessed obscenity from the perspective of both the young and impressionable, as well as those already inclined towards impure and libidinous thoughts, setting a low threshold for censorship. The Supreme Court of India adopted this particular test when it upheld the ban on the famous book D.H. Lawrence's Lady Chatterley's Lover. The book was considered scandalous for its depiction of sexual encounters and faced various obscenity trials in several countries, including the United Kingdom. The Supreme Court of India was of the opinion that unless obscenity served a preponderating social purpose or profit, it merely appealed to the carnal side of human nature and therefore was not protected under free speech. In 2014, the Supreme Court moved away from the Hicklin test and instead applied the Community Standards test in Avik Sarkar versus State of West Bengal, a case concerning the publication of a semi-nude photograph of Boris Baker and his fiancée. The court asserted that obscenity has to be judged from the point of view of an average person by applying contemporary community standards, and that a nude picture cannot be called obscene unless it has the tendency to arouse the feeling of an overt sexual desire. It then concluded that the picture is not obscene because the message it wants to convey is that the color of skin matters little and love champions over color. In recent years, the Supreme Court has liberalized the law of obscenity, balancing it against the right to freedom of speech and expression. In March last year, the Supreme Court quashed all criminal charges against the creators of the YouTube web series College Romance under Section 292 of the IPC, which was the former provision on obscenity, and under Section 67 of the IT Act. The court underscored that there is a fine line between what constitutes obscenity and language that is profane or foul. The key question is whether the web series, when viewed in its entirety, was solely intended to appeal to prurient interests. The Supreme Court observed, while a person may find vulgar and expletive-filled language to be distasteful, unpalatable, uncivil and improper, that by itself is not sufficient to be obscene. Specifically, it held that since the show was a light-hearted show on the college lives of young students, it is clear that the use of these terms is not related to sex and does not have any sexual connotation. Experts have cautioned against the frivolous weaponization of obscenity laws to stifle free speech. As evidenced by judicial precedents, the contours of obscenity must be strictly defined, keeping in mind the existing societal realities and community standards. The aim of such laws should be to penalize the exploitation of children, for instance, child pornography cases, instead of criminalizing consensual adult expression. Thank you. For more such videos, please subscribe to The Hindu.